I made a video 3 days ago stating that the inconsistencies and the procedural error occurred during the trial of Mazen Nnamdi Kanu is going to quash that case before the appellate judge. And I also challenged any lawyer in Nigeria or any judge to prove me wrong as stated in that video. Now I believe that someone has showed up. I don't even need to prove anything here. You picked a section for criminal offenses, right? What are your emphases here? The language or the justice passed? So my emphasis is not going to come in singularity as you request. It is not about the language. The language was spoken in English. We're talking about the judgment and the procedures before the judgment was passed, which in essence violates many sections of the Constitution. Especially, it violates the beginning of the Constitution. Firstly, let's begin with the supremacy of the Constitution to find out whether or not Section 36 violation is enough to throw the case into the dustbin. Mr. Oli, in Nigerian law, supremacy of Constitution refers mainly to Section 1 of the 1999 Constitution. In substance, it says, Section 1 sub 1 of 1999 Constitution, the Constitution is supreme and has binding force on all authorities and persons in Nigeria. Section 1 sub 3 states, if any other law is inconsistent with the Constitution prevails and that other law is null and void to the extent of its inconsistency. How is this section of the Constitution vital or consistent with my claim? So my question, do you agree with me that the trial court conducted a proceedings contrary to Section 36, which talks about fair hearing? If you say yes, then its actions are inconsistent with the Constitution as stipulated in Section 1 sub 3 of the 1999 Constitution. Those inconsistent acts are, and any judgment based on them are void to the extent of the inconsistencies and should be set aside by the Court of Appeal. For the sake of those who have not seen the previous video, I am going to reiterate the sections of the Constitution that was violated during the proceedings by Judge Omotoshe's court. We all know that by the virtue of the law, the job of the judge expands when the accused is unrepresented, to ensure that the unrepresented accused receives a fair hearing without compromising his judicial impartiality. This is a principle that is rooted in the constitutional right to fair hearing, which is a cornerstone of justice. And allow me to show you the path, or we'll use it as a material evidence that will confirm the inconsistencies and the violation of Section 36 of the Nigerian Constitution, when the accused that was unrepresented was begging the judge to show him the law that he allegedly violated that he may defend himself.
Says you cannot try anybody unless the law is written. Show me the written law. Show me the written law.
And I believe you are also aware that Nnamdi Kanu was not allowed to submit his last written address. The frustration you saw thereof was after the court. He was making it known to the world that he requested for the judge to show him the written law that he has violated, that he may enter his trial, but the judge undermined it, which in essence undermines the principle rooted in the constitutional right to fair trial. The appellant was denied the right to a fair hearing as guaranteed by the Section 36 sub 1, in which the unrepresented accused is refused access to the very law under which he is charged cannot meet the constitutional standard of a fair and impartial hearing. Section 36 sub 6 A and B mandate that every person charged with a criminal offense shall be informed promptly in the language he understands in details of the nature of the offense and shall be given adequate time and facility for preparation of his defense. By refusing to show the appellant, who was unrepresented, the written law and specific provisions allegedly violated, The biased trial judge failed to provide the required detail and facilities, thereby fatally compromising the appellant's constitutional right to prepare his defense. Alternatively, DSS facility cannot be adequate to prepare for his defense. Subsequently, the consequences is miscarriage of justice, which leads the proceedings to nullity, because these constitutional breaches are not mere irregularities. They go to the root of the trial and have occasioned a grave miscarriage of justice. In consequence, the entire proceedings and the judgment of the lower court are vitiated and ought to be set aside as nullity. It will conclude with a prayer to the appellate court by the appellant, which will be urging the Honorable Court in vindication of Section 1 and 36 of the 1999 Constitution to set aside the judgment of the lower court together with the entire proceedings and to make such consequential orders, including an order to discharge and acquit the appellant. And outside of the case of procedural error, there are alternatives: jurisdiction, extraordinary rendition, which will be vital in maybe in the next video that I am going to make. But that will not come until a judge or a lawyer proves me wrong on this one.